CR 2019-07-1095, State of Ohio versus Juror Singh. This Friday, October the 21st, 2022. All counsel for the state and president of the court, as assistant technical legal counsel for the defendant, are present along with Mr. Singh. We also have our interpreters present, as well as our court reporter, and are outside the presence of the jury. We are here for some arguments today in regard to the issue that arose yesterday. But before we do that, I do want to address the media, because yesterday evening I was forwarded a photograph of the jurors that was taken in this courtroom by a member of the news media. It was not a photo specifically of the jurors, but it was a wide-angle photo of the courtroom and the proceedings, which included all 12 members of this jury in it. This is the second time that this has happened, and I am not going to tolerate it any further. I will kick every member of the media out of this courtroom if there is another violation of the court's orders regarding photographing or filming members of this jury. These jurors' identities are to be kept private, and I'm not going to tolerate it any further. Am I clear? Yesterday evening, the court received 2 notes from the jury. One that was more concerning than the other, and that dealt with an allegation that one of our members of our jury is not following the law in regard to this case. So I'm here to hear arguments this morning in regard to that juror continuing as a juror in regard to this matter on behalf of the state of Ohio. Are you ready to proceed?
Yes, sir.
Mr. Munich.
Thank you. Is that all right, Counsel?
You may.
Your Honor, may I approach and you give the court a copy of excerpts of the transcript that can also provide context?
And I did receive the transcript. Ms. Fitch stayed up late, early hours of the morning, preparing, and it was sent to me, it was sent to defense counsel, and it was sent to the state as well.
Your Honor, it did not take long for the interpreters to request that the court speak up because they cannot hear you what is being told to me of the gentleman providing.
No, I meant the attorney, attempt to prosecute.
I will as well, Your Honor. And perhaps if you'd like to come up front too, that was his objection.
If you'd like to come up, sir, if you can hear better, I don't have a problem. If you would like to come up, you can even sit in the area. Well, don't sit behind Ms. Fitch because it makes it difficult for her. Why don't you sit over there? Okay, it just makes it difficult for Ms. Fitch to hear if you're sitting right behind her. Mr. Muir.
Well, thank you, Your Honor. On behalf of the state of Ohio at this time, after reviewing both the notes and letters provided by the 2 jurors, and in addition to proceedings last night in chambers, the state of Ohio removed this court for the removal of both juror number 111 and 83 from this jury panel. I believe at this time, Your Honor, the court has been provided a case law that is well within its broad discretion to remove both jurors from this jury in accordance with section 2945.49 and criminal rule 24G. We've also provided the courts a case law with regard to the authority for the removal of these 2 jurors. These 2 jurors individually took it upon themselves yesterday to indicate their own personal unwillingness or inability to continue to perform their sworn duties as jurors. On top of that, I believe the court's questioning of the jury panel indicates that those 2 jurors have also engaged in potential misconduct, which is obstructing the jury process in this case. And finally, as indicated by the court, perhaps most importantly, several of these jurors have indicated that one juror in particular has repeatedly indicated she is not applying the court's instructions and laws required during deliberations. And so basically, the state believes there are three grounds for removal of these individuals. One, they have both told this court they are unable or unwilling to perform their duties as jurors. Two, both have engaged in what the state believes would be jury misconduct because of the interpersonal conflict between these two jurors, which has made it so that the jury process cannot take place. They're not able to deliberate properly. Three, the juror in question who is not following the law, and that's corroborated by each one of the other jurors indicating their concerns to this court. One juror in particular, Juror 83, is not following the instructions by this court. All three reasons would be separate, distinct grounds that warrant removal of these jurors from this juror pool and them to be substituted with two of the alternate jurors. To address each one of them, each one of the points by the state. One, both jurors have sent notes asking to be discharged. And in their notes, they indicated that, and in person, when questioned by this court, they have indicated they cannot perform their sworn duties. It's contained both in writing and in the transcript during the interview by this court. Juror 111, his note indicates, I can no longer in due diligence be on this jury. One juror is not following your instructions or rules. When this court interviewed Juror 111, he indicated, yes, that's my note, I did write that. Juror 83 in her note has indicated, I don't feel safe in here considering the confrontation that has taken place multiple times during this deliberation. And when interviewed by this court, she indicated in response to these questions, do you think you can continue your deliberations? Her reply, I do not. Most importantly, she says, it's not the fact that everybody agrees, it has nothing to do with that. I don't know what's next. So asking me to remove myself because that's not what I'm here for. I have a husband and children to go back to. I feel uneasy being in the room with him. Other jurors note that these two want to be discharged as well during the deliberations. Multiple jurors have said, in effect, neither one of them want to remain on the jury because of the conflict between these two jurors. Second, the other 10 jurors have unanimously corroborated that both of these jurors have engaged in arguing, both are potentially acting improperly, they're confrontational, and that the interpersonal dynamic between these two jurors has impeded the jury deliberation process. Yes, they obviously disagree on potentially what the evidence shows, but all of the other remaining jurors have indicated that they are being disruptive to the jury deliberation process. And so it's not about their views conflicting necessarily with each other, but it's that their interpersonal dynamic prevents the other jurors from fulfilling their duty and impedes the process that this jury is charged to do. The foreman, with regard to this dynamic between these two jurors, has indicated to this court that one of the jurors, Juror 111, one of the ones we are asking to be dismissed, has called Juror 83 an idiot. Juror 95 has indicated we have to tell him to calm down, to stop it, and he sort of raises his voice and keeps arguing. Juror 129 says he's being rude and he should apologize to her. Juror 111 himself admits I've raised my voice at her. I'm just not always going to be able to keep my composure. Juror 130 has indicated, when asked by this court, if one or both of these jurors were removed, would it facilitate your deliberations? Their reply is absolutely. Juror 32 was asked and said, there's two people that are being confrontational. The person that wants to be excused because of feeling threatened is also confrontational. This court asked, can you continue these deliberations and can a verdict be reached with the two of them? Unfortunately not. Both of them are the issue, question mark? Yes. Juror 32, asked by this court, do you think you can continue deliberations and reach a verdict with the two of them in the same room? Reply, no. The court, I took it as you're never going to be able to do your deliberations with these two people in the same room. Juror 95, the two of them are causing delay while they argue. They're not open to other jurors' opinions. Juror 72, the name calling between these two people, I was like, stop, but it didn't stop. Juror 87, we have two people that are both extremely aggressive, and they're basically screaming at each other until we calm both of them down. I think they're both at fault. Juror 129, it's petty nonsense preventing us from doing what we need to do. The foreman himself has indicated that removal of both of these jurors would facilitate deliberation as this court has charged. The other 10 jurors are not fighting. They are trying to engage in this process and perform their sworn duties. And the personal conflict between these two jurors in the state's opinion is preventing the other jurors from discharging their sworn duties. This is not about a deadlock in deliberations. This is not about a deadlock in deliberations. This is a jury being unable to even deliberate because of the conflict between these two jurors is making it impossible. And third, Your Honor, Juror 83 is not following the law as charged by this court, according to several of the other jurors. The foreperson, when questioned, has indicated she is bending maybe some of the instructions on the sheet to facilitate her belief. Juror 32, this court asks, do you feel that juror is not following my instructions or rules? And the reply, you know, I do. She is not following the reasonable doubt instruction. I don't think she's receptive to hearing our thoughts. Juror 95, it's quite possible that one is not following them according to your instructions. Juror 43, she's not following some but not all. I don't think she is following the reasonable doubt. It's like anything can happen. Maybe a Martian can come down and have done it. Juror 87, I take it that the juror that's not following the instructions is female? Reply, yes. Juror 90, when asked about this willingness to follow instructions, or unwillingness to follow instructions, I totally agree with that. That's exactly what I believe is happening. She is substituting what she believes the law should be. Juror 129, when asked if this juror is following the law, I do agree that she's not following the law. Juror 111, when asked if this juror 83 is following the law, replied to this court, that's correct. We've asked her plenty of times to explain her position, but she doesn't. She she says everything is a possibility. She is not following your rules, certain things that you have in there about reasonable doubt and then just having doubt. Your Honor, the status of the vote in this case, whatever it may be, is not relevant to the determination of juror misconduct. The ethnicity and background of a particular juror or jurors is not relevant to the issue of juror misconduct. All three of these separate, distinct bases warrant the removal of both juror 111 and juror 83 from this jury pool. And both have indicated an unwillingness to this court to continue with the deliberations as charged. And in particular, juror 83 has also indicated twice now to this court that she is not willing to perform her duties any further and to her misconduct. This is not about people disagreeing over the evidence. This is about jurors committing misconduct that warrants their removal. If the court would like me to continue to this issue raised by defense counsel for potential misconduct. Your Honor, in that case then, the state of Ohio is requesting that this court protect this process that we began 3 weeks ago, and that the remaining jurors who are part of this pool that are willing to do the job be allowed to do so. That this jury not be held hostage by two individuals that are unwilling or unable to perform the duties as required by this court, and they're not going to follow the court's instructions of rule of law. We are requesting that this court excuse juror 111 and 83 from this pool and allow two alternate jurors to sit in their stead. This case should have the opportunity to be fairly and justly decided in accordance with the rule of law and this court's instructions. The parties, the community, the defendant, the victim's family, they deserve that opportunity for this case to be decided in accordance with the rule of law and not in accordance with jury law. Thank you.
Thank you, Mr. Minnick. Directors.
Your Honor, with court's permission, can I sit down and read some stuff? Is that all right?
Yes.
Thank you. It's difficult because we're cramming this in for the past 12 hours, and I want to make sure I hit all the high points.
Sorry.
It's not out of disrespect.
I appreciate that. Thank you.
Thank you, Judge. What I plan to do, Your Honor, is go through a legal memo highlighting some law set forth by United States Supreme Court case law, and then go back and overlay it, one, with a mile-high summary of what we have had the past 3 days now with deliberations, and two, with some transcripts, similar to what the prosecution just gave you on Fitch's transcription. Removing juror number 83 is contrary to Ohio law and a violation of the free's due process rights and constitutionally guaranteed trial rights. To remove a juror, and I'm quoting from State v. Robb, to remove a juror because she is unpersuaded by the government's case is to deny the defendant his right to a unanimous verdict. The Ohio Supreme Court conspicuously stated in Robb that, and I quote, a juror cannot be removed if there is any possibility that fellow jurors' complaints about her are rooted in her view of the merits of the case. And I'm going to get into that later with the transcripts that we have about the merits of the case and the evidence that they disagree on, which multiple jurors have said they disagree on evidence. And I'll get into that in a minute. But the Ohio Supreme Court is very clear. If the court finds that there is any possibility that the complaints about her are rooted in her view of the merits of the case, she cannot be removed. The fact pattern that is most similar to this case is State v. Bell. That's 2018 Ohio 3486. In that case, an allegation of a juror not following the law prompted the trial court to interview the juror in question, just like the court did in this case. And just like in this case, in the Bell case, the interview uncovered that the juror in question disagreed on the evidence but was following the law and instructions provided by the court. Similar to the trial court's upheld decisions in Robb and Bell, this court should determine that Juror 83 should not be removed because this court's inquiry clearly established that complaints about Juror 83 are rooted in her disagreement that the state of Ohio has met its burden of proof of establishing all the elements of its case beyond a reasonable doubt. No evidence existed that Juror 83 exhibited a, quote, this is from case law, defiant disregard for the applicable law. In fact, it's to the contrary. To the contrary, the evidence established that Juror 83 has honestly and deliberately considered the evidence presented and even examined the jury instructions provided by this court in detail to make sure she was following correctly. Multiple jurors stated the disagreement and deadlock in this jury was due to a disagreement of how they view and value evidence, meaning the complaints about Juror 83 are rooted in her view of the merits of the case, well beyond the standard of any possibility established in Robb. Therefore, removing her from the jury would be contrary to Ohio Supreme Court's holding in Robb and a violation of Capri's constitutional rights. The interviews conducted by this court uncovered that Juror 83 not only read the instructions provided carefully, but that she correctly is reading those instructions and correctly applying the law based on the English language in the instructions on the word may versus must. Frankly, it's the other 11 jurors who are trying to persuade her that she should not and they should not follow the court's instructions. Her interpretation of the word may is exactly right. And we'll talk about that in the transcription. And she and the other jurors, the other jurors are trying to force her to use the word must when the court used the word may in the instructions. This is proof the jury system is working. Juror 83 is following the instructions. Her interpretation is based on honest and reasonable deliberation and her view of the evidence. Juror 83's reading of your instructions is spot on. She is reading and applying the instructions as written. This is not a popularity contest. The other 11 jurors are not better or more correct simply because they don't agree. The idea that the world is round once the minority outlier view was once the minority outlier view, but we know it was not the correct interpretation of the facts. The request for the removal of 83 is not based on a violation of the law or this court's instructions. It's based on the fear of the cost of another trial. It's based on the state's desire to win. It's based on the parties in court now knowing the current status of the deliberations and how each juror is voting. I'll talk about how we know that in a minute. And that knowledge is in and of itself a violation of the law. Ohio Rule of Evidence 606B restricts a juror's competence to testify about, and I quote, any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon his or any other juror's mind or emotions as influencing him, end quote, regarding the verdict or, quoting again, concerning his mental process in connection therewith. And Judge, this is why the Ohio Supreme Court stated that an investigation like this must be subject to strict limitations. This is quoting Robb at 81. Long recognized and very substantial concerns support the protection of jury deliberations from intrusive inquiry. That's quoting Tanner in the United States. Thus, the United States Supreme Court found reversible error where a trial court judge inquired of a jury unable to agree as to the extent of the numerical division. And we know that numerical division, and we know it's 11-1. I will quote right out of the transcript how we know that. Given the nature of the inquiry and information received by the court during its inquiry, it has now obtained the extent of the numerical division within the jury and information about the effect of anything upon Juror 83's mind and her mental processes in connection with the deliberations. Such information is in violation of Evidence Rule 606B and Brassfield. Moreover, if this court removes 83, this court will have eviscerated the Freed's constitutional right to have this matter determined by this jury, and will have converted this into a one-judge panel vote for conviction. When this court gave the Howard charge, juror number 83, along with her 11 other fellow jurors, were told that it is conceivable that after a reasonable length of time, honest differences of opinions on evidence may prevent an agreement upon a verdict. That's the black letter law. The OGI instruction of the Ohio Supreme Court in Howard goes on to state that when honest differences of opinion on evidence exist, the jury may consider whether further deliberations will serve a useful purpose. Coercion, bullying, and duress are not useful purposes. And those are the exact actions that are occurring during deliberations toward juror number 83 and juror number 111. Why should the victim of these disrespectful actions face removal? The state previously cited State v. Jones, a 2022 case, 8th District, in support of its request to remove juror number 83. However, it's juror number 111, not juror number 83, that fits the offensive behavior that warranted the removal of the juror in Jones. And I'll go through that in the transcriptions in a minute. Juror number 83 is participating in deliberations as instructed and has lawfully followed the instructions this court provided for 10 hours now, actually more than that. Like in Robin Bell, juror number 83 must be allowed to stay on the jury because while she may disagree on the evidence, she is following the law and instructions of the court. Statements received by this court during its inquiry are clear that the jury is deadlocked. Statements like, we're at a loggerhead, we can't convince her. After you gave a soft Allen charge yesterday, and you gave a full formal Allen charge, and every juror, except for one, the hostile juror, number 11, agreed that after the second Allen charge, juror number 83, they were unable to convince her, despite multiple attempts to change her mind. We know they're at a deadlock, 11-1. Jurors use the word loggerhead. Jurors use the word we are trying to convince her tonight. After your Allen charge. The fact that the disagreement is on whether reasonable doubt has been proven is proof that the disagreement at hand is pertaining to the evidence. Ohio courts are clear. When a disagreement is on the evidence and whether or not a charge has been proven beyond reasonable doubt, a juror cannot be removed. It's also telling that the sole...
Yes, slow down.
Thank you, Judge. Sorry. It is also telling that the sole individual on this jury and the one that the state of Ohio seeks to remove is the only African American on the panel. The court would remove this woman who deliberated, made up her mind on the evidence, simply because she does not agree with the majority and refuses to convict someone when she believes the state has not met its burden. The purpose of our system is not to beat people who disagree and take issue with the evidence. There's a mechanism for this, and that is called a mistrial. To remove this juror from the panel would blatantly violate the Freed's constitutional rights and ensure a conviction. You would send an alternative juror or two into a room with 10 or 11 jurors who've made up their mind for the past 3 days. I would like to go through, Your Honor, an overview with some of these transcriptions of what you heard yesterday in the voir dire process. The jurors got the case around 4:30 on Wednesday, deliberated for about 2.5 hours. Then on Thursday, they came in yesterday about 9 in the morning. We went till 10:30 at night, but there were a number of breaks. So 13.5 hours minus breaks. You gave a soft Howard charge yesterday morning. They continued to deliberate for several hours. Then you gave a formal Howard charge after the jurors indicated that they were deadlocked, that they could not reach a unanimous verdict. And after the formal Howard charge, there were approximately 5 more hours of deliberations, during which time all the jurors remained in that room. All the jurors were working to deliberate. Juror number 83, under your inquiry, said, you told me to go back in the room and deliberate, and I did. During your voir dire process, every single juror who was asked whether or not each juror has had the ability to discuss the case throughout the deliberation said yes. Every juror that you asked whether or not every single juror was engaged in listening said yes. No juror indicated that there was any name calling from juror number 83 to juror number 111. Multiple jurors indicated that the name calling and abusive behavior was from number 111 back to 83. One of the other female jurors indicated number 83 deserved an apology by the way she was treated, but had not received one. One of the other jurors indicated that number 111 was, quote, hostile toward 83. Multiple jurors indicated that 111 was the person who was name calling at 83. No juror indicated that 83 ever was name calling, hostile in any way towards any juror. No profanity is accused to have even been used at all by either, any juror. And I'm going to cite the pages of your transcript, of the transcript that this Fitch made, Your Honor, of your inquiry into each juror last night. Page 3, line 17. About the evidence, this is your question. How they view the evidence, you're asking how they're feeling. Answer, yes, exactly. And what their conclusion is upon the evidence, how they see it. They're telling you that the disagreement between juror 83 and the rest of the panel is based on her view of the evidence. That's page 3, line 19 and 20. Instead of one of the jurors not seeing it the same way as the others. Page 3, line 22 and 23. They have a disagreement on the evidence. On page 14, line 25, your question, Your Honor. Okay, is everyone in the jury room getting to express their opinions and views in regard to the evidence and the testimony of the witness and things like that? Answer, yes. Has anyone been prohibited from doing that? Answer, no. Page 16. Jurors answering your question about the stalemate. Your words, Your Honor. The stalemate in the back. That's the court's words. What is the reason behind the stalemate? That's the court's inquiry into this juror on page 16. And the answer is, I said, no matter what we say or how hard we try, are you going to change your mind? And the answer was no. You said, okay. And this juror says, that was 3 hours ago. After your Allen charge, after your second Allen charge. You said, okay. And this juror said, and we've been working on it ever since. Want to know the reasons why that juror has made her decision. Well, Your Honor, this is 10 hours into deliberations on the second day after 2 Allen charges, and this juror has said she has gone through all of the evidence and made her decision. This is evidence, your words, Your Honor, of a stalemate deadlock jury. Page 17. You said, are any of you not following the instructions that have been given? And this juror said, I don't think that she is following reasonable doubt. But there was no inquiry into what that juror's opinion of reasonable doubt is. It is absolutely understandable in this country, especially looking at the definition of reasonable doubt. Lawyers don't agree on what it is. Our prosecution defense didn't agree on it in this trial. When they are asked a leading question by the court, whether or not she's following the instructions, they have a disagreement on the law. And we'll get to what she said in a minute. Juror number 83 is actually going back to your instructions, word by word, pointing the other jurors back to it. And it is the other jurors that disagree with what the instructions said. 83 is pointing back to the instructions and expressly and specifically said she is following the law to a T. The fine print is her words. On page 20 of the transcript, you're asking why 2 people have a difference of opinion. And on page 17, the answer is they don't want to change their mind. And this juror is using the word there to refer to a singular person, which is juror number 83. And then the others become hostile. So then they're becoming hostile, and it's just becoming like a screening match. This is after, again, 2 Allen charges, deliberations, and juror 83 making her decision based on her own life experiences and common sense. Page 22. A juror tells you there's one word. This is the hang-up. So when the court asks a leading question to the jurors, is she following the instructions? And most of these jurors are like, well, that's a hard answer. That's a hard question to answer. I don't know. You get that a lot. Well, in my opinion, maybe. The answer to this is very telling. There's one word in there that says, like evidence may be, and she is saying it doesn't say must. So then it's like one word is throwing it off. This is a juror telling the court, and there are other jurors that told the court the exact same thing, that juror number 83 is pointing to the jury instructions that were given by this court and that are Ohio law, pointing to something in the English language, which is the word may, and indicating to the other 11 that she may give certain weight to testimony, but there's not a must. And these 11 jurors don't like the jury instructions. And juror 11 is going back to the jury instructions and the English language, explaining to them what the word may means. And she is right. Juror number 83 is right. Page 23. Question from the court. Do you think the instructions are being followed other than the way that juror is applying the instructions to the evidence? Answer. We keep referring to it, meaning instructions. Like we will read paragraphs out of it, or like the Johnny ate the apple pie. We keep reading that into, and I don't know. Answer from the court, okay. And the juror says, I feel like everyone is trying to. Meaning follow the instructions. Everyone. Page 26. Questions from the court. Is everybody being or given the opportunity to talk in there? Answer. Oh yeah. And voice their opinions? Question mark. Answer. Yes. And talk about the evidence? Answer. Yes. Question from the court. And state what they believe the evidence has shown? Answer. Yes. Question from the court. No one is being prohibited from doing that? Answer. No. The inquiry from the court clearly shows that there is a disagreement on what the evidence shows. That there is a disagreement between juror number 83's interpretation of the evidence in this case and the other 11 jurors. Page 28. You question, court questions, what they're screaming about. And the answer is, I guess, the disagreement about the evidence. That is the answer on page 28 from the juror. They disagree about the evidence. This goes back to Rob in the Ohio Supreme Court, that if there's any possibility that the fellow jurors' complaints are rooted in their view of the merits of the case, the juror cannot be removed. And this theme about the jurors disagreeing on the evidence continues. Page 30. Question from the court. They want to believe what they want the evidence has. They want to believe what they believe the evidence has shown in the case. Question. Answer. Yes. Page 31. Question from the court. Applying my instructions? Answer. Yes. Yes. Applying your instructions. Question. And why do you say that? Answer. Like I said, because we spent a lot of time in there going through the evidence. We put it all on the paper. We put it on the board. We've discussed it. We've reviewed it. And I don't know, I guess it is their opinion, again referring to number 83, to have a different opinion. You know, they're able to have a different opinion. But everybody else is able to come to the same conclusion, but they're not. Again, the inquiry now is a violation of 606. We know it's 11-1, deadlock. And this juror continues. And no matter what, I guess every angle that we presented, they just don't see it that way. Court question. Do you think that that person is not following the law? And again, the court is referring to number 83. So you ask, do you think that person is not following the law? Or they just don't believe that that's what the evidence showed? Answer, well, I guess they just don't believe that's what the evidence showed, period. Page 32, question from the court. I know you probably don't know anything about him or her feelings safe, but there's been confrontation back in the jury room? Answer from the juror, yes. Question from the court. Because of this juror's opinion of the evidence, or because of what they don't like the rest of you, or what? Answer, because of this juror's opinion of the evidence. Yes. They have a disagreement on the evidence. Question. You're asking about applying instructions. The juror says, well, that's a difficult thing to answer. And says, you know, I guess that's the person, their opinion, it's what they believe. Right. Answer, it's their interpretation of the evidence. On the top of page 33. This is a common theme throughout your question. The interpretation of the evidence is a disagreement in the back. The juror continues on page 33. I guess I can't say that they're necessarily not doing anything, you know, by the law or by your instructions, but it is just the way that they feel. Okay, you ask, Your Honor, so do you think they are following my instructions? Answer from this juror, to the best of their ability. Period. End of answer. Next page, 34. You're asking again about following instructions. Answer from this juror on page 34. I think it's very unfortunate. We've spent a lot of time with this juror trying to read the instructions. So they're reading the instructions, we know that. Most of the hang-up is around the evidence. That is reasonable doubt. And you know, that argument. And so we've stopped. And we've gone through a couple bits of evidence. And we've tried to gain some consensus around small things. And this person, referring to 83, is just very contrarian. Just often says that it's a possibility. And we've tried to convince this person to give their side of the story and what you think the facts are that could dispute this. We're kind of at a loggerhead. Again, it's your words, Your Honor, a stalemate. Page 35. Question from the court. When you say that all of you have tried, is everybody being given the opportunity to express their opinions on the evidence? Absolutely is the answer. Question. No one has been prohibited from doing that? Answer. Absolutely not. We have an easel, whiteboard, trying to follow again some different pieces of evidence that we either agree on or disagree on. And we keep coming back to, you know, reasonableness of your opinion. That this can't be correct. And the answer is, well, it's a possibility something else happened, and I'm not sure. We must have heard that 20 times. This juror is talking about them trying to convince her that the evidence is something that she doesn't believe it is. Page 37, the court says, have you all had a chance to talk about the case? Answer, yes. Discuss your opinions? Answer, yes. Voice your opinions? Answer, yes. Express what you believe the evidence shows or didn't show? Answer, yes. Every single juror you inquired about, Your Honor, said that they have discussed their opinions. Everyone has been heard. Everyone is listening. Everyone is engaged. Page 39. You're asking about the dispute between the two jurors. And this juror on line 9 says, I can't really say he doesn't weigh on that. You ask, all right, but you think that the other juror, that you think all of you are following the instructions? Answer, yes. There's not an issue with that? Answer, no, I don't think so. I mean, we are all new to this. Question. So it just may be a difference of an opinion. Answer, yes. Bottom of the same page, 39. The juror continues. If they've already made their decision, I don't know if they're just wanting to get back to their lives or what. Again, signifying to this court that we have a deadlock jury. Page 42. The judge, you, Your Honor, asks, do you think it's just this juror's interpretation of what the evidence showed, or? And this juror on page 42, cuts you off in your question, says, there is one word in the document that you provided to us that is, and this person says, and I quote, I don't have to accept it, I quote, may accept it. This juror, like the other juror that you've inquired, said that she, number 83, is pointing to your instructions, pointing to a word in the English language that says may. Actually, juror number 83 is telling the others, you need to look at the instructions, and the others don't like what the instructions say. Page 43. Hours ago, she, number 83, said, I'm not going to be persuaded. None of you can persuade me. I've made up my mind. We might as well get the bailiff. Question from the court. And that is when I brought you back out and gave you the answer from the juror. That's after we went back in, after you spoke with us. So this juror on page 43 is telling the court that after the second Allen charge, juror number 83 said you might as well get the bailiff because you're not going to persuade me. After hours of deliberations, after going through all of the evidence in the exact formula and manner that the foreperson, the other 11 wanted to, and participating, she said, I made up my mind. On page 45, I think this is very telling because this juror was one of the quotes the prosecution said indicated that juror 83 was, quote, not following the law. When the court asks a leading question, do you think this juror might not be following the law? A few of the jurors are like, yeah, I think that she might not be, because they don't know what the law is, to be very frank. How do we know that juror 83 is following the law and the other 11 are not? I'll tell you how we know that, actually. But this juror who said she's not following the law starts crying and says, I just don't know why she can discount expert testimony. That's her reason, Your Honor. This juror says the reason why juror 83 isn't following the law is because she discounted expert testimony. Juror 83 is following the law to an absolute T. If we were forced in this country to not be able to discount testimony or expert testimony, we would not be following the law. And this juror was crying, telling the court that the reason juror 83 was not following the law is because she was discounting expert testimony. Page 47. And again, you're asking about the hang-up between juror 83 and the rest of the jurors. And this juror tells you, again, well, we're all unanimous, but it's just you. That's page 47, line 14 and 15. We're all unanimous, but it's just you. Again, telling the court and the parties, in violation of Rule 606, to count 11 to 1. We're all unanimous, it's just you. And this juror continues on page 47. We're just going back and forth. Nothing seems, and she is like, go get the bailiff right now because I'm not changing my mind. Page 49. Again, after this court's inquiry into each juror, this juror tells us the count in the back in violation of Rule 606. Page 49, line 19. Everyone is unanimous except you. And she feels like I'm being targeted, I'm being interrogated. And we're just like, explain your position. And you said, and she won't. And the answer to that is, not really, no. She is hung up on one thing, through the trial. She's hung up on something. She has reason to doubt. On page 55, Your Honor, you are inquiring into juror number 83. And she tells you that she's asked juror number 111 to stop being disrespectful. She tells you that she's asked him to stop being disrespectful multiple times. And you ask her directly what she has to say about the accusation from the hostile juror, number 111, that she's not following the law. And her answer, number 83, and I quote from page 55, "I followed the rules, and I think it made them," meaning the other 11, especially him, meaning number 111, "a little upset that I was reading the fine print." Juror number 83 indicated to you on your inquiry that she is reading the fine print of the instructions, which is upsetting the other 11 jurors. I was the one that actually suggested that the foreman follow, meaning your instructions, because they had their own formula of how they wanted to go through the information, which I participated in. But I actually was reading from the documentation that you provided word for word. That's what she tells you. He, on the other hand, was completely different. He's standing up, walking around. He keeps standing up behind the seat, walking over here. I don't know what he's going to do. He was clearly very angry, very aggressive. Thankfully, I'm on the other end of the table. He kept standing up, hitting stuff, being very aggressive. She's the victim in a deadlock jury by one very aggressive juror, number 111. And it is absolutely not dispute that there is a dispute in the back about the evidence of this case and her interpretation of it. It is also not dispute that she is actually going to your instructions, pointing the other jurors to your instructions, and they don't like one word in the instructions or the interpretation of the English word thing. You actually asked her a second time, despite how clear she was in your question about following the court's instructions. You asked her again on page 56, "Are you following the court's instructions?" Answer, "I am following the court's instructions, and I believe that some of those people in there don't believe that I am. But when I quote what it says in the documentation, like you may consider versus what you must, they didn't like the fact that I was saying that I may consider something, not that the court is not saying that I must." Some people don't agree with that. She's saying some people don't agree with your instructions. Some people were like, "Well, that is what it says, but..." So yes, I'm definitely following your orders, she tells you. There was no inquiry on what any of these jurors believed reasonable doubt to be. There was no inquiry on whether juror number 83, her version of reasonable doubt is contrary to the law. Your inquiry directly to her, whether or not she could follow your instructions, was very clear. And it is also very clear that these jurors are deadlocked, attempting to get a woman who is the only African American left in the panel to change her mind. And she is firmly convinced that the proper verdict should be not guilty in this case. From the start of this case, Your Honor, the state used two of its preemptories to remove African Americans off this panel. Two. There were three possible. The state used two preemptories to remove African Americans from this panel to start the case. They used their other ones to remove people with higher education, like a chemist out of Procter & Gamble. Now, as we sit here today, there's one African American left on this jury. As a person with brown skin is on trial for murder, for his life, and the state is asking the court to remove the only African American left on this jury, after the evidence is abundantly clear that there is a disagreement on what a proper and just verdict should be, that the disagreement is based on the evidence, that at best, numerous people have indicated that everyone is being listened to, everyone is having an opportunity to speak, everyone is actually pointing back to your jury instructions and following the law. Rule 606, Your Honor, I believe, and the Ohio Supreme Court case law would tell us that an inquiry to the foreperson and then maybe an inquiry into number 83 and number 111 should be the extent of the inquiry last time. But what we have now is the government knowing the status of deliberations, knowing that one juror who has a different set of life experiences as an African American woman in this country, and her own common sense, disagrees that the government has proved its case beyond reasonable doubt. That is the common thread in your inquiry into these jurors. That there's a disagreement on reasonable doubt, that the juror, number 83, is citing to a word a word may, which is absolutely correct. She's actually citing the fine print of your instructions, and the other 11 jurors do not like it. These jurors have told you that they're at a loggerhead. You have indicated yourself that there's a stalemate. You have given 2 Allen charges, and a mistrial is absolutely appropriate at this point. It is horrible that the state of Ohio is asking this court to remove the juror that they now know does not believe the state has met its purpose. Removal of number 111, by the way, cures number 83's safety concerns. She would have no safety concerns. She said the other 10 are being respectful. Jones says that it's appropriate to remove the abusive juror, not the removal of the victim. And at this point, Your Honor, because of the court's inquiry and because of what that elicited regarding the 11 versus the 1, I don't think that the court has any other choice but to grant a mistrial. Nothing else.
Mr. Ricker's repeated statements of reason to doubt is exactly the problem in this case. The defense counsel does not understand the court's instruction and cannot read it for himself. And that multiple jurors have claimed to this court this statement of reason to doubt or it's possible, which shows that juror 83 is not following the instructions issued by this court. And it's just stupefying to me. Defense counsel says this court doesn't have the right or ability to inquire into the status as it is done when the Ohio Supreme Court in Rob 2000 Ohio 275 specifically invests this court without authority. But yet somehow Mr. Ricker stands up and argues contrary to Ohio Supreme Court. Defense counsel conveniently forgets and doesn't mention this isn't a case where 11 people have contacted the court to complain about one person. This is that one person sending this court herself a note asking to be excused and that she will not continue deliberations. So he may be very passionate and side with her and her claims of victimhood, but that is not the case. She sent a letter to this court asking for her own removal, claiming she cannot and will not continue. So this is not these fantastical allegations that she's some kind of victim. She's the one that contacted the court herself. The status of the deliberations, how people will vote is immaterial. The question is there juror misconduct? And here, there is no indication of deadlock. The state objected previously to the Allen charge and Howard charge being given because 2 personal notes from 2 jurors running off this jury do not constitute deadlock in the state's opinion. There is no formal documentation from the foreman saying this case is at a deadlock. We have 2 jurors who just simply don't get along, and it's created a hostile environment for the remaining 10 jurors. And Mr. Richter stands up and patently, falsely, and inaccurately makes a statement to this court that this juror 83 is not hostile. That is just not true. I'm not going to read the entire transcript like Mr. Rickers wants to, but
these jurors say there's been victory. They just keep snipping at each other. It gets pretty heated, high intensity. I think there's two people that are being confrontational. The person that once excused, aka Juror 83, because of a feeling of threatened, is also confrontational. Juror 72 describes a screaming match between these two jurors, that they're scaring each other, that they have accusations towards each other. Juror 72 describes that they are hostile towards each other and name-calling. And I don't think those two people are going to work together. Juror 87, we have two people that are both extremely aggressive. Both are passionate. They don't seem to like each other very much. There's two hyper-aggressive, passionate people. I mean, they're basically screaming at each other until we calm them down. Juror 90, they've had some words back and forth. Juror 16, there's been some confrontation. Yes, sir. Between those two jurors? Yes. Okay. And I think they're both at fault for that. Juror 111, one of the jurors in this, says she's very condescending, very argumentative. So, Mr. Ricker's standing up in open court and saying that she's the victim and she's not hostile in any way is wholly, completely, factually inaccurate. These other jurors indicate she is part of the problem. Now, as Mr. Rickers keeps saying she's a victim, I guess he believes that because she claims she's a victim. When these other jurors disagree, why must both these jurors be removed? Because both are being disruptive to this process. Both are creating an environment where this case cannot be deliberated. The fact that she is applying her own standards cannot be allowed. Simply because jurors can express their own opinion does not mean deliberation has been taking place in this case. And clearly, given the notes from these two jurors, no deliberations have been taking place due to these two individuals and the environment that they've created. And so once again, both jurors have said they can't perform their duties. Both jurors are indicating there's misconduct in the jury room. The other jurors agree to preventing deliberations. And juror 83 is being indicated that she is not following the court's instruction. All three are separate reasons for their dismissal. Now, I tried to abide by the court's instruction not to talk about this mistrial issue. But given that defense counsel has done so, I feel I have to reply. Obviously, the court's aware that a mistrial is warranted when they indicate that there is no probability that these jurors will agree in accordance with 29:35:36. And I continue to state that this court does not have an indication of deadlock. This jury was deliberating together, even after given a full Howard charge. The foreperson said, we'll try. I think a verdict is possible. They even asked for a transcript of testimony, which was denied by this court, to try to provide some fruitful indication that this could be, this deliberation could continue. And these most recent communications from this jury is not a statement of deadlock. It's a statement of personal animosity between two particular jurors that will not participate in the deliberation process. And I believe the court's own take on those notes and the inquiry into these jurors indicates the court's own concern that this is not an issue of deadlock, but of animosity. In none of these cases that have been cited does a court conduct this questioning and then declare Well, there's a deadlock, so this is mistrial. If a juror is excused, as the court is allowed to do, then the deliberations should continue. And the court should instruct to begin anew with the alternate jurors. If the jurors are not excused, then the court should send them back to continue deliberating, because until they indicate there is a deadlock in writing, I believe a mistrial would be inappropriate. Thank you.
Thank you, Mr. Munich. Your Honor? No. I am going to take a recess, and I'm going to review my notes and review what counsel has provided to the court. I'm going to clear up a couple of things. There were a couple of, at least one mistake. This court did not give an Allen charge or a Howard charge after the court received the notice of jurors. That was done well before that. The court gave a soft Howard charge in the morning when there was an indication that they were having difficulty in their deliberations. It was only after the court was not happy with the process, because I specifically gave them paper to write down any questions or issues. From going forward, maybe I'll change it, not just leave the question on there, put an issue. But there was an indication to the bailiff that they were, what do we do? We are not able to unanimously reach a verdict. And that's when the court gave the Howard charge, the full Howard charge, and sent them back into deliberations. Just want to make that clear. There was an indication that the court gave the Allen charge after the court received the notice from the jurors, and that did not happen in this case. It was after the notice, the court convened with counsel in chambers with the court reporter to what hear these jurors. So I'm going to take a brief recess. I can't tell you how long it's going to be. I'm going to take a little bit to review my notes, the transcript from Ms. Fitch that she was up doing until very early hours this morning, along with my other notes I took from yesterday, and I'll be back in shortly to announce my decision regarding the decision. All right?
All rise. This court stands in recess.